If you've done nothing about GDPR so far, I certainly wouldn't say you're doomed, but you are at risk. But Elizabeth Denham, who is the Information Commissioner, has made a point of saying that the 25th of May and the introduction of GDPR was not a deadline, it was the beginning. But certainly act now. I would say this is not a case where you can put your head in the sand and hope this is going to go away. So for those who have done nothing, the starting point has to be this data mapping exercise. Find out what data you hold about all of your employees, how you use it and why, and map across to those lawful bases for your processing. That has to be your starting point. So the key for this new regime is that passive compliance is really not an option. So employers and HR teams need to be able to demonstrate that they are complying and how they're doing so. So under the old Data Protection Act, we had really quite heavy compliance on consent for processing data. So we saw in most employment contracts a global clause that said, you will consent to us processing your data pretty much in any way that we like. And there are prescribed legal bases for processing data. So the most likely lawful process in an employment sphere, if you like, will be either a contractual obligation, a lawful obligation or a legitimate interest. What's also important for HR teams is to revise their subject access request procedures. There are some subtle changes which, if they're not picked up by HR or those who deal with the requests, would render them in breach. So for example, we always had 40 days to comply with the subject access request, and now that's been reduced down to a calendar month. So we're only talking about a handful of days difference, but it could be enough to put someone in breach. It's not just about compliance internally, but inevitably you will be transferring data externally. So for example, as an employer, you may deal with third-party suppliers for private medical insurance, or you may outsource your payroll, for example. You'll be transferring that higher level of data that involves someone's health information, for example. So you'll be transferring that outside your organisation, where you will lose that control over how it's processed. So what's really important is that any contracts are updated to ensure that you have comfort that wherever that data is transferred, those third parties will also be compliant with GDPR. So it will be really important for staff to be able to identify where there's been a potential breach, so that employers can not just spot it, but they can respond to it quickly and they can mitigate any potential loss that arises. Also, what's important to bear in mind is there's now a 72-hour window in which breaches need to be reported to the ICO, where an individual's rights and freedoms are at risk, and that's a very strict deadline, and it's important that that's complied with by all organisations who process data. The key consequence of non-compliance is this massive hike in the penalties that can be awarded by the Information Commissioner for non-compliance, and in the most serious of cases we're talking about 4% of annual global turnover, or up to 20 million euros, and that's a massive increase on the old regime, which was a maximum of £500,000 fine. We don't really know what the landscape will look like post-Brexit, but one thing that's clear is that the essence of GDPR is here to stay. So Brexit will not be the get out of jail free card that many people have suggested in terms of data protection compliance. So we've already updated our data protection legislation. We now have the 2018 Data Protection Act, and that encompasses the essence of GDPR.